The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon and welcome to the arguments of the Kansas Supreme Court. I'd like to welcome counsel as well as those who are listening to us through our Supreme Court Live channel. We're looking forward to the arguments in this case after having read the briefs submitted by the parties. Just quickly, because we have some faces that are new or relatively new to the court, I want to be sure that everyone is aware that this week is the first docket week for our newest justice, Justice K.J. Wall. We welcome him to the court and are pleased to have him joining us. Also, because we are saying goodbye on Friday to our colleague, Justice Carol Beyer, as she retires. She is not sitting with the court this week. So we are very pleased to have sitting with us Judge Mike Ward, formerly of the 13th Judicial District, now retired, but acting as a senior judge assigned to this court. So we appreciate his help with our docket this week. With that, counsel, we'll be ready to ask Mr. Shima to call the case, and after that, we'll ask you to enter your appearances. So I would then ask the clerk of the appellate court, Mr. Doug Shima, to please call the afternoon case. Mr. Shima.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Wednesday, September 16th, 2020 consists of one case. Appeal number 117439. Alicia Tillman and Storm Fleetwood versus Catherine Goodpasture, D.O., Riley County, briefs both sides. The argument is set for 20 minutes each side. The appellants Tillman and Fleetwood reserve 5 minutes rebuttal time. The appellee Goodpasture and Office of the Attorney General as intervener will divide their argument at 10 minutes each. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Yes, Your Honor. Lynn Johnson on behalf of plaintiffs, appellants, petitioners, Alicia Tillman, and Storm Fleetwood.
May it please the court, Jacob Peterson, counsel for appellee, Catherine Goodpasture, D.O.
Good afternoon. Brant Lau, Deputy Solicitor General, appearing on behalf of the Office of the Attorney General as intervener.
Thank you, counsel. With that, I would ask Mr. Johnson as the attorney for the appellant and petitioner. You may begin your argument, Mr. Johnson. Thank you.
Thank you, Your Honor. This is a Kansas common law medical negligence cause of action brought by Alicia Tillman and Storm Fleetwood as parents of baby A against Dr. Goodpasture for the recovery of their monetary damages as allowed by Kansas common law, sustained as a result of Dr. Goodpasture's negligence, which denied them the right to make an informed decision whether or not to terminate the pregnancy of a fetus with severe physical and neurological defects. The Kansas Legislature, through the enactment of KSA 60-1906, has denied Ms. Tillman and Mr. Fleetwood their right to recover those monetary damages sustained as a result of Dr. Goodpasture's medical negligence. KSA 60-1906 is unconstitutional because it denies plaintiffs their right to trial by jury and denies plaintiffs their right to remedy by due course of law. This matter has had a long history. The original cause of action was filed in 2016, and here we are in 2020 before the Kansas Supreme Court arguing with regard to whether the statute is defective and unconstitutional because it violates the right to trial by jury and the right to remedy by due course of law. I feel somewhat like deja vu all over again because, as the court may be aware, I represented John and Nicole Arche in the Arche versus United States of America case that was decided unanimously by this court in 1990 in an opinion written by Chief Justice Miller. We're here today because the 3-judge panel of the Kansas Court of Appeals determined that the Kansas Supreme Court recognized wrongful birth as a new tort, not an extension of an already existing claim for medical malpractice. The new tort of wrongful birth fashioned in Arche in 1990, according to the panel, was based on public policy that sprang into being in 1973 and could not have existed in 1859 just because the tort of medical malpractice existed in 1859. First of all, that is an incorrect statement of the law. The Kansas Supreme Court, through Chief Justice Miller in Arche, did not designate the medical negligence wrongful birth cause of action as a new tort, but rather as an extension or as an evolution of common law tort of medical malpractice. It's interesting to note that Chief Justice Miller, who wrote the opinion, also wrote the opinions in the other previously decided medical malpractice tort actions that dealt with the issue of wrongful life, wrongful pregnancy, and wrongful birth. And I think it's noteworthy that Chief Justice Miller was very knowledgeable with regard to these causes of action, these common law causes of action that had been considered by the Kansas Supreme Court prior to the consideration of the common law medical malpractice wrongful birth action in Arche. It's of interest to note that Justice Miller cited in his opinion in the discussion that there were 3 types of related medical malpractice torts that would be helpful in the analysis. And he noted that those torts were wrongful pregnancy, wrongful life, and wrongful birth. And as he noted, they have all evolved because of advances in technology and the recognition of a woman's right to prevent conception or to terminate a pregnancy. He went on to evaluate the Kansas cases that had considered wrongful life and wrongful pregnancy. And then he went on to analyze and evaluate, I believe, 20 or 21 cases from other jurisdictions that had recognized the common law cause of action, common law medical negligence cause of action for wrongful birth damages suffered by parents of a child who was born with significant defects.
Mr. Johnson, I think what you're basically espousing is that this wrongful birth is just a different application of concepts of negligence in a medical malpractice situation. And what I'm wondering here, it just seems like it changes the structure, the very nature of wrongful birth, in that who is the compensable victim here? It typically is the person or the individual that suffers the harm. And here it's a third party who's affected by the injuries. And it just seems to me that changes the structure. And it seems unique or different from just an extension of your typical medical malpractice cause of action. How do you respond to that? Explain to me how that change of structure just as an extension rather than making it something new.
First of all, the doctor who was sued in this case and in most of these cases, our plaintiff, Alicia Tillman, was her patient. So the physician-patient relationship was between Dr. Goodpasture and Alicia Tillman, just as in most medical negligence cases. So the cause of action that has evolved as a common law cause of action merely allows the parents, specifically the one parent who had the physician-patient relationship, to recover monetary damages as a result of that negligence, to recover monetary damages because of the deprivation of the right to make a choice, the informed decision. As Chief Justice Miller pointed out, we assume that plaintiff Nicole Arche was denied her right to make an informed decision whether or not to seek an abortion under facts which could and should have been disclosed. So this is, first of all, we have to prove, and I think that everyone would agree, we have to prove that Dr. Goodpasture fell below the standard of care. We have to utilize the PIC instructions, and the jury would determine whether she was or was not medically negligent. We then turn to the issue of what did her negligence cause in terms of an injury. And as all of the courts have stated, the most recent being the Iowa Supreme Court has stated, that injury is the failure to provide the opportunity to make an informed decision that Ms. Tillman had the right to make based upon the decision by the United States Supreme Court that there was a fundamental right to an abortion and that declared a statute unconstitutional, which, as the court knows very well, this court has now established a fundamental right in the HODUS decision that was decided last year. So I'm not sure if I'm answering your question other than—
I'm not sure you are either. My question really has to do with, again, is the injury is, the physical injury is to baby A. And it's the third party that's affected by those injuries. It just seems that changes the structure of how we look at this tort, as opposed to your typical medical malpractice. Or maybe, and I understand you think it's just an extension of what already exists. Is that basically?
No, it's not only what I think, Your Honor. It's what every court that has decided this issue has stated. We put in our brief to the district court, which we've included in volume 1, pages, I think 51 through 59, all of the cases that Chief Justice Miller relied upon, and all of those cases discuss it in terms of it being an extension of medical malpractice. And in fact, as I noted earlier, Chief Justice Miller noted that these torts, these medical malpractice torts, wrongful pregnancy, wrongful life, and wrongful birth, have evolved because of advances in technology and the recognition of a woman's right to prevent conception. So we have to prove the same elements in this case as we would in any other medical negligence cause of action.
Counsel?
Yeah.
That's a good opportunity for me to jump in with my rather more theoretical question, which is, can the legislature change or modify any of the elements of a negligence cause of action ever? Or is your position that whatever those elements were in 1859 are locked in forever?
I think it's pretty well established through a variety of cases that the legislature can modify the common law, but cannot do so without providing an adequate quid pro quo with regard to Section 18. Now, as this court has decided in Bilburn, there is no quid pro quo required for a violation of the right to trial by jury. And what I'd like to, yeah, go ahead.
I'm sorry, if I could explore that a little bit further. Could the legislature by statute state as a matter of law that the duty element has changed in some fashion, however they want it to change it? When we have common law that defines duty and the legislature says, well, we think the public policy should be different, so we're going to define duty a little bit differently. Is that?
I don't think the legislature could do that constitutionally, because that would be modifying the common law in a way that would change the common law to the detriment of the individual.
What about changing evidentiary thresholds? So for example, our state recently went through an adoption of what I would characterize as a higher evidentiary threshold for the introduction of expert testimony. Arguably, that changes the ability of parties to bring negligence actions. Why doesn't that interfere with the Section 5 or Section 18 right?
Because that's a procedural issue rather than a substantive law issue. The manner in which an expert is evaluated with regard to whether he or she should be allowed to testify has always been a procedural issue and not a substantive law issue. So I don't believe that the legislature can change or modify the common law. And I don't think that it can, through attempting to do that, abrogate the right to trial by jury or the right to remedy by due course of law. If we look back at Kansas Malpractice Victims Coalition versus Bell, and all of this is cited in our briefing, I'm simply repeating things that are in our brief, is that the common law allows for the recovery of damages for negligent injury. And therefore, the right to trial by jury applies here. I'm quoting from that case. This is a common law cause of action for the recovery of damages by Ms. Fleetwood, by Mr. Fleetwood and by Ms. Tillman for negligent injury to them. And going back to the other question, the injury is not to the child.
Right.
The injury, as has been defined in every case, is the injury is the inability to, through an informed decision, decide whether to terminate the pregnancy or not. That's the injury. So we're not talking about an injury to the child here.
And why can't the legislature say, as a matter of public policy in the state of Kansas, the lost opportunity to terminate a pregnancy is not, as a matter of law, an injury?
Because if the Kansas Supreme Court in Arche would have done what the Kansas Supreme Court has done in other cases, for example, in the dram shop issue, the recent Kudliak versus Johnny Shawnee Inc. case, where the Kansas Supreme Court has on at least 2 or more occasions has said, this is a matter of public policy for the legislature. And because the legislature has not enacted a dram shop law, we are not going to intervene, or we are not going to establish a common law cause of action. Here, the Arche court did not say, okay, this is something that we can't decide because we're going to refer this to the legislature. This is a matter of public policy to refer to the legislature. Instead, the Arche court unanimously determined that, as Justice Miller said, this is a medical malpractice wrongful birth action. And so, the whole argument that the defendant and that the Court of Appeals has seemed to rely on here in discussing public policy really has no place here. Public policy is not an issue. The Roe versus Wade case decision was not a public policy decision. That was a constitutional issue wherein the US Supreme Court determined that a Texas abortion statute was unconstitutional. Just like the Hodis case is not a public policy decision. It was a constitutional application of the Bill of Rights. So public policy, if the court in Arche had thought, oops, this is something we can't do, we can't decide that we are going to expand the common law because of new technology and the right of a woman to choose now constitutionally guaranteed, they decided this is a common law cause of action. Once they made that decision, it is a common law cause of action for the recovery of damages for negligent injury, period. It's nothing else other than that. And all the case law that everybody cited, the right to trial by jury is inviolate for causes of action for the recovery of damages for negligent injury. I may have gone further than what you wanted, Your Honor.
No, thank you.
Counsel, let me, let's
assume that this is a traditional medical malpractice action, just like the Iowa Supreme Court said a couple of years ago. And the injury is to the deprivation of choice of the mother and father. How do you get around the fact that at the time of statehood, the territorial laws would not have provided that mother and father the choice that they had at the time of Justice Miller's decision? It seems to me that if we go along with all of so much of our case law that says Section 18 has a focal point, and that focal point is the time of the Constitution. If you didn't have the choice, even under a traditional medical malpractice action at the time of the Constitution, how do you have a cause of action that gets protected by Section 18? You see my point?
Well, I think several ways to respond to that. First of all, as the Lemuse court said, this is a negligent cause of action. We start there. This is negligence. And as the Lemuse court said, which we believe supports our position, not as the Court of Appeals noted that it supports their position, that common law negligence actions are continually evolving. And as the Lemuse court said, let me just grab it and quote it here. If, according to the defendants, the corporate negligence doctrine, well, let me back up. Yeah. The corporate negligence cause of action are not new causes of action, but are simply different applications of the basic concepts of negligence, which existed at common law. Negligence existed at common law and are protected by Section 18. If this were not the case, then any evolution of negligence law since the time the Kansas Constitution was adopted could be abrogated without implying or implicating Section 18. So this is an evolution of negligence law. And we could say this, Your Honor, about a lot of different evolutions of the law. Think about strict liability, 402A. Well, in 1859, there was no such thing as strict liability, 402A. Many of the restatement of torts that the Kansas Supreme Court has adopted as the common law of Kansas, those things didn't exist then. So you could look at almost any of the evolution of the Kansas negligence common law, product liability common law, medical malpractice common law, and you could say that they didn't exist in 1859. CT scans didn't exist in 1859, et cetera. Now, in direct response to your question, I believe this court has answered that question in the Hodis opinion, and we briefed that or discussed that in our appellant's reply brief that we filed June 11th of 2019, wherein those laws, which are somewhat suspect as to whether they were really criminal statutes, may or may not have been and probably were not constitutional. So we can't get so wrapped up in that issue. All we should be focused on is the common law allows for the recovery of damages for negligent injury, and therefore the right to trial by jury is inviolate for any such cause of action.
And I understand that you don't want us to use the time of the Constitution as a focal point, but I've set that aside for a second. It seems to me the territorial laws that made this choice illegal impacts the common law, and they can't be declared unconstitutional because Section 1 of our Constitution didn't exist until the Constitution was adopted. So I've always looked at Section 18 as being sort of a pre-Constitution analysis as to whether a cause of action existed.
and I can assume that this is a regular medical malpractice. I have less problem with that than I do simply saying that the injury you're talking about, the deprivation of choice, didn't exist at the time of the Constitution.
Let me just, the injury is not the critical issue with regard to whether Article or Section 18 or Section 5. That's not the critical issue. For Section 5, and it's clear through our brief, and they even discuss it in the Court of Appeals. Issues of law must be tried to the court. I'm sorry, issues of fact arising in an action for the recovery of money or specific real or personal property shall be tried by a jury. So the injury is not the issue. The issue is the negligence and the recovery of damages for negligent conduct. So we could presuppose all kinds of injuries that may not have been, possible in 1859. And I don't mind going back to 1859 because this common law cause of action for the recovery of damages for negligent injury existed then. This is, as Chief Justice Miller pointed out, is an evolution based on advances in technology and the recognition of a woman's right to prevent conception. So the legislature cannot, simply because it doesn't like abortion, simply cannot step in and deprive these folks and others similarly situated of their right to remedy by due course of law and their right to a trial by jury on whether the defendant doctor was negligent and whether that negligence ultimately caused their monetary damages as prescribed and as defined in Arche. I think the Court of Appeals and the defendant and the interveners really simply want to reconsider the Arche opinion. There's an interesting quote in the Court of Appeals opinion after they talked about the Bruggerman case, which is the wrongful life case, in which the court stated, quote, "Life is precious and worthy of protection. To claim one is entitled to damages for the birth of their child when they claim they would have aborted the fetus does not protect and value life," end quote. That to me is really the underlying reason for the Court of Appeals opinion, is for whatever reason, that panel of Kansas Court of Appeals judges just simply doesn't believe the Arche opinion is right, and that the issue of abortion was inserted here. That is not an issue that we should be looking at. And I know you're not looking at it, but the point of whether Nicole Arche or whether Alicia Tillman, going back to 1859, could or could not have had an abortion is really begging the issue of whether the common law cause of action for negligence and the recovery of damages for that negligence was justiciable at common law, which it was.
Counsel, you're not claiming that the choice was abrogated. The choice was still there completely, correct?
I'm sorry, I don't quite understand.
Well, you're not claiming that the mother's choice was taken away. You are claiming that this amorphous set of variables that constitutes her choice was somehow harmed. Correct?
Yes, it was denied. It was denied because the ultrasounds that were done if read properly, revealed the extent of the fetus's very serious defect.
Wasn't denied. She still had that choice. She simply didn't exercise it because she alleges that this being, this amorphous thing that is her choice, was harmed somehow, correct?
No, I mean, not really, because the issue here is, we have to take our petition to be true. And in our petition, we specifically allege that the ultrasound was misread, negligently misread by Dr. Goodpasture as being normal, when in fact it was not normal. And that was a breach of duty to Ms. Tillman.
And so you're alleging that because that was done, she lost her right to choose.
Correct, because the negligence of Dr. Goodpasture, again, taking our petition as being true, was that there were one or two, and I'd have to get the petition, but ultrasounds, which were negligently interpreted by Dr. Goodpasture. She interpreted them as being normal, when in fact they were not normal. Now, that has to be taken as true here. We will have to prove that when we go to trial, but to be taken as true, then that deprived Alicia Tillman and Mr. Fleetwood of their right to make a decision with regard to whether to terminate the pregnancy. And we have alleged, and it has to be taken as true, that she would have chosen to terminate the pregnancy. Thereby, this child would not have been born, and the Alicia Tillman and Storm Fleetwood would not incur the extraordinary expenses that the Kansas Supreme Court has determined are allowable in a medical malpractice wrongful birth cause of action.
And there you mention possible new elements beyond what typically would be proven in a negligence case. We beyond duty, breach of duty, you now have, perhaps you could call it a causation element, but perhaps it's a new element of showing how it infringed on the ability of the parents to make the decision, and that they indeed would have made a decision to terminate. That is not something you necessarily would have to prove in a typical medical malpractice case. Does that change the character of the cause of action?
Not really, because as has been pointed out here, that the injury is the inability to exercise informed consent. And in an informed consent case, just a regular informed consent case, where the allegation is that the physician failed to provide appropriate information, which deprived the plaintiff of the ability to make an informed consent, the plaintiff has to prove that if the plaintiff would have been provided that information, the plaintiff would have had the surgery, would not have had the surgery, or whatever. So it's no different than that. It's no different than any other informed consent medical negligence case. Does that make sense?
Yes, I understand your point.
But then, to the extent that you have at least a factual variance, how is our court, what guides our analysis in determining when we're dealing with a new cause of action as opposed to just another new or nuanced application of a common law remedy?
Well, I think that we've set this out in our brief, and even the Court of Appeals noted that undeniable, I'm quoting from the Court of Appeals now, on page 70 through 71. Undeniably, common law tort actions were historically triable to a jury. Similarly, wrongful birth is undeniably a tort. Thus, the question is whether Section 5 preserves a right to a jury trial in every tort, since the right to a jury trial generally applied torts at common law, or whether Section 5 only applies to torts recognized in 1859. If Section 5 of the Bill of Rights applies generally to torts, then KSA 60-1906 is unconstitutional. They go on to state, we have been unable to find any case in Kansas where a court has addressed whether Section 5 guarantees the right to a jury trial in a common law tort first recognized after the Kansas Constitution's adoption. Historically, the Kansas Supreme Court has considered the general nature of the cause of action, whether equitable, statutory, or an action at law, rather than the specific cause of action alleged in determining whether Section 5 applies. Based on this case law, and they cite the case law, based on this case law, whether a party is entitled to a jury trial seemingly depends on whether the case was triable by jury at common law before the adoption of the Constitution. So I think an answer to your question is that there is no Kansas case law, no Kansas Supreme Court law, other than the Kansas Supreme Court law that has considered the nature of the cause of action, whether equitable, statutory, or an action at law, rather than the specific cause of action alleged in determining whether Section 5 applies. I'm quoting directly from the Court of Appeals opinion, and this is in our brief, that since this is a common law negligence cause of action for monetary damages, the Kansas Supreme Court has historically always held that the right to trial by jury is invoked in any such case, regardless of what it's named. Then the Court of Appeals goes on, and I won't delay this because I know I'm way over time. They cite the Lamuse case, which I believe really supports our position. And then they cite the Leiker and the Brown cases. But as we pointed out, the Leiker case has to do with wrongful death. In the Leiker case, wrongful death was not only not recognized, there was no wrongful death common law cause of action, period. And the Brown case had to do with governmental immunity. And since the right to sue the state for torts was a right denied at common law, not just that it wasn't there, it was denied, such right is not protected by Section 18. So the bottom line is, there is no Kansas Supreme Court opinion directly on point with regard to the issue that you now face. Historically, this court has held that the right to trial by jury and the right to remedy by due course of law protects all common law negligence actions for the recovery of damages. And no matter how you slice it, that's what this is. It's a common law, determined by the court, negligence, medical negligence, we have to prove, cause of action for the recovery of money damages.
Your position is that if it fits into the negligence category, it implicates Section 18?
Yeah, for the recovery of monetary damages. That's what the Kansas Malpractice Victims Coalition versus Bell goes on to say, the right to, I'm quoting, the right to a jury trial then turns on the type of remedy sought. In other words, it has to be money damages, not negligence asking for specific performance. That's an issue that a judge would decide. So it's negligence, money damages.
Other questions? Thank you, Mr. Johnson.
You're welcome. Do I still get 5 minutes?
Yes. We asked more questions, I think, to take that time. So
Thank you.
We now turn to the attorney for the appellee. I understand the appellee and intervener are dividing their time, and that Mr. Peterson, you plan to go first. Is that correct?
That's correct, Your Honor.
Yes, please proceed.
May it please the court. First off, I do want to clarify a few of the comments that counsel for the appellant made in his argument. There was a lot of emphasis on what the nature of the injury here is. And counsel's perspective is that the nature of the injury is that the injury really is to the rights of the parents. But that sort of articulation of what the nature of the injury is isn't consistent with the Arche opinion. As we go on in the Arche opinion, there's an analysis of what kind of damages are available for the wrongful birth cause of action. And specifically, they held there that emotional damages to the parents aren't available because they weren't witnesses to the injury in that case. The injury in that case is the condition of the child at issue there. But regardless of what the injury is or the nature of the injury, the result here is very important. Torts are, by definition, civil wrongs that are to be avoided. We give compensation to try to put plaintiffs back in the position that they would have occupied had the tortious conduct not occurred. But here, the result of this tortious conduct is something very different. As the court in Arche talked about, the result here is the existence or the benefit of a child. That is something that is entirely different than a traditional sort of tortious analysis. And it seems somewhat crass and somewhat wrong to try to think about, well, we're going to award damages to sort of undo what is alleged to be the tortious action here, because the result of the tort is the existence of this child, this living being. And that's one of the significant things that really sets this tort apart from traditional negligence, which is really the heart of the issue here. And as I think Justice Biles pointed out, the heart of this Section 5 and Section 18 inquiry really is, was this wrongful birth cause of action justiciable at the common law in 1859? And I don't believe that anybody is alleging that a court actually recognized this wrongful birth action at that time. And there are other things that set it apart, aside from kind of the policy and the purpose behind this action. As I believe Justice Luker touched on, there are some additional elements here that the court in Arche identified. Those additional elements are the idea that, look, the child must have a disability that's not medically correctable and that is so severe that they will never be able to live a, quote, normal life. Those are additional elements and additional proof that simply are not required under a traditional negligence analysis. And furthermore, the recognition of this tort inherently recognizes the concept of one life being more valuable than another. It's uncontroverted that the plaintiffs in this case would not have a viable cause of action either before or after KSA 60-1906 if the child at issue was a, quote, healthy, normal child. But here, we're recognizing a cause of action based on the condition of this being. And that's a balance, that's a value judgment that simply is foreign to a traditional negligence type analysis.
Mr. Peterson?
Yes.
When do those differences between the traditional claim and wrongful birth make a legal difference, and in the sense of implicating Section 18 or not? That's what I'm trying to understand. And what guidance or framework or factors do you suggest in assisting the court in making that decision?
The line, I believe, is delineated by that Lamuse case, and I respectfully disagree with counsel on whose side of the case that case actually supports. We believe that the Lamuse case supports our position because there, with the corporate negligence cause of action, the court ruled that Section 18 was implicated because all that was happening there was simply plugging in a new duty, and I believe that was the literal phrasing of the court, plugging in a new duty to the basic elements of negligence. That's all that happened there. We just recognized that hospitals had a duty to reasonably privilege physicians that were practicing in hospitals. Here, there's a whole lot that's different. In addition to the proof, as we articulated, there's the policy issues that we discussed elsewhere. Does that answer your question, Justice Wall?
Counsel? Yeah, I think you're getting closer. In what I guess, what are the elements of the cause of action here, and as distinct from a traditional negligence claim?
Right. So this claim, as counsel pointed out, there will be duty, breach, causation, and damages, but there are those two additional components that they need to prove. A not medically correctable disability that's so severe that that child will never be able to live a normal life.
Counsel, let me run you over to Mr. Johnson's articulation of what I consider to be a typical informed consent medical malpractice case. And how does this differ what you've got here? I mean, again, I'm fairly persuaded by that Iowa Supreme Court case. Now, you know, you're welcome to disabuse me of it, but it seems to me they articulate why this is an informed consent case. And so what's your response to that?
Well, Your Honor, I believe that it relates back to those distinctions that we talked about before. There's no question that this cause of action shares some characteristics with negligence. And as counsel pointed out, this did evolve from existing law. So to that extent, it does bear similarities with an informed consent cause of action. But there you have an individual person talking about whether or not they would have made a decision about their own medical treatment and how that decision would have affected their condition later on. Here we've got a distinction where we have a child that is existing. We're comparing that to a hypothetical healthy child that the parents would have alleged that they would have wanted to give birth to. This is about the choice of the parents to have a specific child. And that is a notion and a concept that is completely foreign to traditional sort of negligence analysis.
Let me jump in, counsel. If the facts had been a failure to diagnose so that there was no informed consent about whether to go ahead with the pregnancy, and the pregnancy harmed the mother, the delivery of the birth harmed the mother, they're home free, aren't they? I mean, that's a traditional medical, you wouldn't have any problem with that fitting all of the parts of a traditional medical malpractice case, right? You've got an injured patient because of the failure to diagnose, because the patient wasn't told of the birth defects so that she could elect to have an abortion to avoid a safety or health issue to her. And she's hurt from it, right?
That's correct, Judge. As you articulated, the injuries to the mother based upon the treatment that was rendered by a physician is a common law cause of action that it wasn't existent in 1859. But this, again, is something different. And I feel like the discussion keeps falling back on, well, on the issue, the policy issues associated with recognizing the cause of action or tort of wrongful birth. But here, that's not the issue. The issue is whether the legislature has the power and ability to articulate public policy related to that wrongful birth cause of action. It's not about whether or not, as counsel pointed out, whether or not we're really re-arguing the Arche case. We're not. The Arche case was decided and the legislature weighed in. Yes, Your Honor.
Before you're out of time, I understand your argument about the cause of action not existing in 1859. For purposes of my question, I want you to just assume we disagree with you on that we think this cause of action definitely existed in 1859.
Okay.
My question is, why can't the legislature by statute alter or redefine certain elements of that cause of action? And I'll preface this just by saying that I think our legislature has done this numerous times. One of the potentially obvious examples is that at common law in 1859, a plaintiff could not recover if they were contributorily negligent. And the legislature adopted comparative fault statutes that changed that element of the negligence cause of action, arguably. How is this any different?
Well, Your Honor, this again is affecting different substantive policy interests than a traditional negligence cause of action.
Right. Why can't the legislature do that? That's my question. What is it about the Constitution that prohibits the legislature from doing that?
From determining whether or not the wrongful birth tort is justiciable in Kansas courts?
Yeah, just saying we as the legislature don't like the common law and we're going to modify the duty element, we're going to modify the causation element, whatever, the damage element.
Mm-hmm. Well, I think the key there is again, looking back to whether those modifications, and I'm sorry I'm not more specific with this, but the key is whether those modifications relate and substantively change what somebody could have sued for at the common law at that time. If the legislature's determination or action would have changed that is, from our perspective, the rule and the test for whether what the legislature did is a constitutional one or not. Going back to the contributory negligence example that you posed, Your Honor, that really is about thresholds of proof. It doesn't redefine what factually would be a basis to bring a viable cause of action. Maybe later on the jury could say, well, the plaintiff was partially negligent here, therefore the plaintiff shouldn't be able to recover, which is the contributory negligence rule that you were referencing. But they still could bring a cause of action in Kansas courts to attempt to recover under the fact pattern, the hypothetical fact pattern that we're discussing. Does that answer your question, Your Honor?
I mean, and I'm not sure how much overlap there'll be with you and Mr. Lau, but let me just ask you this. Does the 1906, the statute in question here, effectively immunize or just not hold liable a healthcare provider who either knowingly or negligently misrepresents or from disclosing known birth defects? What's the consequences for a healthcare provider that does that?
Right. Well,
there is no consequences there as a result of this.
Well, Your Honor,
this statute.
So the consequences in tort via a civil cause of action would not exist, as you're indicating, Justice Rosen. But we need to keep in mind that medical providers have licensure requirements for.
I'm talking about the I understand about the professional potential consequences, but the legal consequence really is none, is there?
The effect of the KSA 60-1906 is to bar a cause of action based upon the notion that they would have obtained an abortion in a different factual scenario. So the court is right that in that scenario, under tort, in a civil cause of action, there would not be a recovery by a plaintiff in that scenario. And I believe that is a question that is available for the legislature to decide, and one that is fully within their power to make a decision about whether Kansas courts can hear and whether the Kansas judiciary should be able to award damages based upon this cause of action for the reasons that we've articulated before. I don't mean to step too much over time because I want to respect Mr. Lau's time, but does the court have any other questions for me at this point?
Counsel, you mentioned you believe this is whether the parents retain their choice to have a specific child. Can you expound on that? Is that related to public policy?
Yes, Your Honor. So expanding on that idea, part and parcel to this tort is the idea that the parents wanted to have a child. And then based upon some tests and analysis that was conducted, they discovered that some characteristics of the child were not ones that would have led them to want to continue the pregnancy. They already made the decision to have a child, but based upon the characteristics they know about, they didn't want to have the specific child or the specific fetus that was in the womb. And that does implicate certain matters of public policy. As the Kansas legislature has articulated on numerous times, they believe that and the people of Kansas believe that life begins at conception. And as the court articulated in Arche, there are a number of public policy concerns at issue here relating to damages, whether or not we're going to recognize full tort damages, the value judgments that we've talked about before. And all of those reasons implicate public policy concerns and tie into the reason why we think and why the courts that haven't recognized wrongful birth, of which there are several, articulated that the legislature is really the entity in government that's best suited to make a determination about this because it is so wrapped in public policy concerns.
Are there other questions? Thank you, Mr. Peterson.
Thank you, Your Honor.
Mr. Lau?
Good afternoon, and may it please the court. Again, I'm Brant Lau, Deputy Solicitor General, arguing today on behalf of the Attorney General's office as an intervener. Just a few brief opening comments, and then I thought I would turn my attention to some of the subject areas of the questions that have been asked this afternoon. This court has repeatedly stated that sections 5 and 18 of the Kansas Bill of Rights preserve the right to a jury trial and the right to a remedy only as to civil causes of action recognized by the common law as it existed in 1859. Plaintiff's wrongful birth cause of action was first recognized in Kansas in 1990 and clearly does not qualify for protection under sections 5 and 18. As a result, the plaintiffs are asking this court to expand the reach of sections 5 and 18 to protect any judicially created cause of action, no matter how new or novel, as long as it allows the plaintiffs to seek money damages. That expansion is contrary to this court's precedents and would create some separation of powers issues. Let me first turn to the question that Justice Wall addressed to counsel about how the analysis should proceed in a case like this. We believe that it's really a totality of the circumstances analysis. If you look at all of the points and factors, they all point in one direction, that this was not a cause of action that would have been recognized in 1859. Look first at the Arche decision itself. In Arche, the court repeatedly gave the indication that it was recognizing something new. The word recognizing is replete throughout the opinion. Indeed, the court relied on changes in our culture and technology, the kind of policy analyses that would as easily be addressed in a legislative hearing. The court's opinion had a concurrence by Justice Six. Justice Six explicitly referred to the claim recognized in the case as a new claim or a new tort. And then some years later in the OMI decision, the Kansas Supreme Court, in a majority opinion, explicitly referred to the finding in Arche as a new cause of action.
Are you suggesting that as medical science progresses, which it obviously has since 1859, I mean, the idea of x-rays, the idea of sonograms, the idea of CT scans, and it's going to continue to evolve. And we'll encounter all new kinds of injuries as we evolve over the next 50 or 100 years. Is it your position that as those new injuries occur as a result of new interventions through medicine and science, that Section 18 and Section 5 precludes a tort action in those? I don't understand why if something's new, then it's precluded by Section 5 and Section 18.
No, we wouldn't argue that everything new is always precluded. We would argue that that is one of the elements in the totality of the circumstances to be considered. And we think here all of those elements point in the direction of this being a new cause of action because, of course, the Kansas courts have explicitly referred to it as a new cause of action. But then you have to look at the elements of the cause of action. We have the very traditional elements of a negligence cause of action: duty, breach, damages, causation. But that's not enough to prove a case under this cause of action that was adopted by the court in Arche. There are multiple additional elements that frankly are present because of the nature of the case. There is a third entity involved, in this case, the condition of the unborn child. And the Arche court specifically said, you must also look to whether the child had a disability and whether the child could never live a normal life. And those are things that would never be reached
Isn't that
in a regular negligence case.
Counsel, aren't those just aspects of the damage element?
No, those are actually elements that have to be found to find liability, but I would agree that damages are different. Well, in particular, the court found a separate and new measure of damages for the case, which is yet a further indicator that this is a different or new cause of action. In the Arche case, the court found the extraordinary cost measure of damages, which is not the usual measure of damages in any other type of negligence action.
You heard my questions to Mr. Johnson and Mr. Peterson. I'm going to ask you the same set of questions, which is, assume for me that this cause of action, we are convinced by Mr. Johnson's argument, this is just a medical negligence action with facts, you know, the kind of advanced medicine that didn't exist in 1859. So it's just a traditional negligence action. It existed in 1859. My question is, why can't the legislature redefine that cause of action or elements within that cause of action?
I would argue that as an original basis in reviewing Section 5 of the Kansas Constitution, that the legislature could. The legislature defines the.
Has the Kansas Supreme Court ever held that Section 5 prohibits the legislature from making a modification to a cause of action?
No, I don't believe that it has. And arguably, Section 5 should be.
Why isn't that your argument then, I guess, is my last question.
That is certainly a secondary or backup argument. If the court rules against us under the existing precedent in Kansas, we would argue that a more appropriate test for Section 5 is that the legislature can define causes of action as a matter of the separation of powers. The issue then becomes, is that new cause of action one that would have been subject to a right of the jury right? And that would be an issue for the court to determine. But sure, we would agree as a secondary argument that the legislature has the ability to alter and amend causes of action in that manner.
And why do we focus on the cause of action versus the type of remedy, which has traditionally been a dividing line as to whether or not a party is entitled to a court trial versus a jury trial, whether it lies in equity or whether it lies in damages. And you know, what is the justification to freeze us in 1859 in terms of what causes of action should lead to damages and the damages that should be heard by a jury?
I think part of the reason that we are all using the term cause of action is because that was the term used by the legislature in 1906, the statute here, where it said that there would be no cause of action. But to move beyond that, the argument that essentially the plaintiffs are making and that you're referring to, Your Honor, is that any action involving damages or negligence, no matter how or when created, must be one that traces back to 1859. And I don't think the delineation is entirely black line between, okay, this is an equitable cause of action as to which there's no jury right, and this is a legal cause of action as to which there is. I think there must be some role, must be some room for the legislative branch to have a say without necessarily intruding on the right to a jury trial.
Why? Why is that? I mean, we carry this over to even the criminal side, where we have looked at where the juvenile offender's right to a jury trial might arise or might not arise. Again, what we have looked at is not so much what just really as to the type of punishment. We look at the end result. I'm equating that to some extent with the damage type of situation. Again, we look at remedy versus what is the underlying, for lack of a better phrase, cause of action that moves it forward.
Sure. I don't think this would be analogous to the criminal situation, just because of the role of the legislature in setting causes of action and the ability of the legislature to amend the common law.
But does not the court have a role in that as well?
I'm sorry?
Don't courts also have a role in creating that common law? And why are we freezing the court-made common law at 1859?
I think this case actually illustrates that. Yes, the court created a new common law decision, a new cause of action, then the legislature amended it.
Mr. Johnson used strict liability as another example. That's another place where courts evolved in the area of products liability.
Well, the line of courts, the line of cases that are cited here, of course, involve lots of tort reform cases, which is a fairly common instance of the legislature amending common law statutes. In those situations, the court has created the quid pro quo test, which we haven't really gotten to yet. But we would argue that, of course, quid pro quo no longer applies to Section 5, but even as to Section 18, it's not appropriate in a case like this, and that this case involves a state interest being asserted separately from any need for a quid pro quo, and that the statute can and should, if the court chooses to not apply the existing law that we've cited, Leiker, Lamuse, and Brown, then under a new regime, the statute could be maintained because of the legislative interest that it was based on when it was passed.
And I guess my question is maybe just even a little higher, more philosophical, another a level above that. In that, what do we have that indicates to us that the framers of our Constitution intended that there would not be evolution in common law causes of action that could not make a difference here? When I look back at the case law, none of it seems to really address why, what the background would be that gives us that intent. Do you have anything from the historical record or otherwise that helps cement that? No,
I don't, other than the obverse of what Your Honor just referenced. What is there in the Constitution that affirmatively says that that role is for the court? I think the best answer, without some sort of unique constitutional history, which I'm not aware of at this point, the best answer is that the structure and nature of the Constitution created both a legislative branch and a judicial branch, and that the relative roles have to be dovetailed in a case like this, or in the circumstances that you're referring to. There's a role for both, and again, this case is an example. the judiciary created a new cause of action. The legislature rescinded it.
Mr. Lau, then does Section 18 then serve as a constitutional limitation on that Article 2 power vested with the legislature?
Well, there would be an issue as an original matter of how much of a limitation it is.
But
And I believe,
But first of all, well, what is the state's position as to the purpose for its enactment?
well, our first position in this case is that under the existing precedent of this court, that the statute should be upheld because of, it was not a cause of action that was available in 1859. If the court wishes to re-examine.
I'm sorry, I think maybe I was being more philosophical too. I'm just trying to understand, given the text of Section 18 and its historical context, what is your position as to its purpose?
So moving away from existing precedent and looking at Section 18 as an original matter, our argument would be that as an original matter, the best approach would be to allow the legislature to control the causes of action. And the guarantee in Section 18 is that those courts be open and available to hear those causes of action. And an attempt by the legislature to take away that right, for instance, to say that this cause of action can only be heard in our administrative tribunal to deal with that particular subject matter. That would create an issue because it would be a violation of the open courts principle of Section 18.
So in other words, for whatever remedies the legislature would define, it's the court's function under Section 18 to ensure due recourse to that legislative defined remedy?
I believe that's fair, yes.
And how does that square with history? In that most causes of actions have evolved through court-made law. We do not have the legislature saying these are the elements of negligence. These are the elements of various other torts. As compared to the criminal code where it is very clear that we recognize the crimes as defined by the legislature.
I think it actually squares quite nicely, Your Honor. I believe going back to the territorial statutes, the state adopted the common law effectively by statute, thereby recognizing the role of the courts in developing that law, but without ceding its power and authority to alter and amend or create new or unique causes of action. So although the history is that criminal statutes have typically been, the criminal law has typically been refined by statute, and civil common law causes of action have been a matter of court-made law, that doesn't mean that that's exclusionary. Frankly, the legislature simply have not been as active in that area. The assumption would be that they are satisfied with the causes of action as they've been developed under the common law process in the courts. And when they're not, as for instance in this case, they make a change.
Section 18 says, all persons for injuries suffered in person, reputation, or property shall have remedy by due course of law. I mean, that's the language of Section 18. And it's pretty much your position that the legislature can limit those injuries that are suffered in person and reputation and in law however they want. And there's really no recourse in court. Is that what you're saying? Is that there's really it seems to me that's what you're espousing, is that the legislature just has the power to determine what injuries are compensated for.
Of course, all of this is assuming the court chooses not to apply the existing law and precedents in Liker, Lamuse, Brown, and such. In other words, if the court decides we're going to go a new direction, this is a case of first impression, or we're not going to apply that past precedent, and we're going to take an original look at Section 18? The direct answer is yes. The original view of Section 18 as part of the structural constitution would lead to a conclusion that the legislative branch will take primary authority for altering or amending common law causes of action. And so long as they allow access to the courts for those causes of action covered by Section 18, there is no constitutional issue.
Are there other questions? Thank you, Mr. Lau.
Thank you.
Mr. Johnson, you reserve 3 minutes for rebuttal.
Okay, can you hear me?
Yes.
Okay. As I listened to the presentations by the defendant and the intervener and their discussions about public policy, it's really clear that most of those are discussions and arguments that could have been and were in fact made when the issue was argued before the Kansas Court of Appeals that resulted in the Arche decision. One thing I would like to point out is that consistently the defense and the interveners and even the Court of Appeals have stated that the OMI Holdings Inc. case stands for the proposition that the Supreme Court had referred to wrongful birth as a new cause of action based on public policy. And we've said this in our briefing, I'll just say it again, that the site that they point out in OMI is really what the plaintiff, OMI, is asserting. The Kansas Supreme Court has never said that the wrongful birth medical negligence cause of action is a new cause of action based on public policy. And nowhere in the opinion does Chief Justice Miller talk about it being a new cause of action based upon public policy. Just 2 or 3 other points. The additional elements issue, and I think someone actually covered this in a way, and that is that the additional element, so to speak, of the child's condition, that simply relates to causation. I mean, it's not an additional element any more so than in other cases. I would also note that in terms of, I think Justice Biles mentioning the Iowa case with regard to informed consent being the sort of the injury and the cause of action. If we look at Chief Justice Miller's decision, he states, under Kansas law, if it were determined that the child would be born with physical or mental defect, Nicole Arche could have chosen to have an abortion. And he goes on to cite Roe and also KSA 21-3407. We assume that plaintiff Nicole Arche was denied her right to make an informed decision whether or not to seek an abortion under facts which could and should have been disclosed, end quote. So not only does the Iowa court talk about informed consent, but that was what Justice Miller was talking about in recognizing a medical malpractice wrongful birth cause of action. And again, we go back to what did Justice Miller, what did he say in his opinion? When he made the decision to adopt the medical malpractice wrongful birth action, he starts off by saying, quote, a plaintiff must prove 3 elements to prevail in a medical malpractice action in this state. And he cites those 3 elements. And then he goes on with the cite I just read. And then he goes on to say, we further assume that there is negligence on the part of the defendants, that the gross defects could have been determined by appropriate testing, et cetera. So he puts this in the context of a medical negligence cause of action for the recovery of monetary damages. And I don't know that it makes a difference whether this is a new tort or a cause of, or simply a medical negligence case that is evolved because a new tort has the same rights as an old tort, so to speak, because a tort is nothing more than a negligence cause of action for the recovery of damages. But just to, for once and for all, put aside the point that has been made by counsel for defendant and interveners that the court has said this is a new tort and et cetera. Justice Miller, in analyzing the difference between a wrongful life case and a wrongful birth case, stated as follows, quote, "There is no legal right not to be born." It's talking about a wrongful life case. There's no legal right not to be born. And allowing an action for being born would create a new tort, comma, rather than applying established tort principles to technological advances. That is a direct quote where Justice Miller is differentiating between a wrongful life case, which would be a new tort because there is no legal right not to be born, rather than, as he points out, applying established tort principles to technological advances. All of these issues that are being argued really come down to the defendant and the interveners really not liking the Arche decision. And that decision was made. The Arche court could have referred it to the legislature by saying this is a public policy issue like has been done in the dram shop cases and others, but did not do so. Rather, it followed the lead of the majority of jurisdictions. I'm not re-arguing the case, but a majority of jurisdictions, including Iowa and Oklahoma and Colorado and our other neighbors, have adopted the medical negligence, quote, wrongful birth. And that's the problem. If they wouldn't have named it wrongful birth, but rather the right of parents to bring this action, we wouldn't be having this issue. But, you know, there's 23, 24, 25, cases from that many jurisdictions, including Kansas. So we don't want to re-argue this. This is a common law cause of action for the recovery of damages caused by negligence, which is protected by Section 5 and Section 18. And as was said in Hilburn, Section 5 involves a fundamental right, so there's no presumption of constitutionality, and there's no reason to show a quid pro quo, which clearly there is no quid pro quo here. This statute did not make any attempt to provide an adequate substitute remedy. Thank you.
Any questions of Mr. Johnson? Thank you. Thank you to all three counsel for your arguments. The court will now take this matter under advisement, and court is in recess until 9 a.m. tomorrow morning.
I only have one other point, and that is, Your Honor, I was doing this in 1990 when we argued the Arche case, and I'm still here arguing to try to keep it alive. Thank you.